One.
Good afternoon, everyone, and welcome to the Connecticut Paid Leave, Understanding the Connecticut Paid Leave Act webinar. We're pleased to be able to introduce this webinar today on behalf of the Black Business Alliance. My name is Anne Marie Knight. I'm the director of BBA. We have a mission to build, grow, empower, and strengthen Black-owned businesses around the state. And our partnering organization today is the Southern Connecticut Black Chamber of Commerce. So we welcome you to this webinar. It will be recorded, will be posted on our websites. And I am thrilled this afternoon to be able to turn this over to Andrea Barton-Reeves. Welcome.
Thank you so much, Anne-Marie. It's our pleasure to be here today. I'm here with our agency assistant, Amber Forrest, and we are delighted to be able to share some information that we hope will help in better understanding the Connecticut paid leave law. So I will turn off my camera because I find myself to be my own distraction, and then we'll go from there. All right. So as Anne-Marie mentioned, I am Andrea Barton-Reeves, and I am actually the inaugural CEO of the Paid Leave Authority. The authority was signed into law in July of 2019 by Governor Ned Lamont, and I came over to get it started about this time last year on March 2nd, right before the pandemic hit. Prior to coming to the Paid Leave Authority, I was the president and CEO at HARC, which is a large nonprofit that supports people with intellectual disabilities and their families. I have lived in Connecticut for 25 years. I'm originally from New Jersey. I have an undergraduate degree in English from Rutgers, and I have a law degree from New York Law School. Today we'll talk about the paid leave program itself, give you a brief overview of the leave laws, the role of the employer, and how the application for paid leave benefits will actually work. We'll speak a bit about implementing paid leave in the workplace, some about private plans, registration, additional resources, and then we'll stop and take some questions and hopefully provide you with some valuable answers. The Paid Leave Authority has a mission to provide pathways to accessible paid family and leave benefits and to help employers and administrators and healthcare providers by giving them tools that can help them understand their roles and to support them while they navigate the program. We have 5 primary responsibilities at the Paid Leave Authority. They include outreach and engagement, which is the opportunity to speak with you today, and thank you again, Anne-Marie, for having us. Developing the policies and the procedures that are needed to run the program. We also established a trust fund contribution rate, which statutorily can go no higher than 0.5% of wages. We approve and audit private plans where employers choose to offer their own plan in lieu of participating in the state plan. And finally, we administer claims for paid leave benefits, which will be available in January of 2022. Here is a timeline of some of the key dates. Registration for employers, meaning that they will come to our site, ctpaidleave.org, and tell us that they are aware of the paid leave program and they're withholding the 1% began in November. Employers began deducting those employee contributions through wage reductions or deductions in January 1 of this year, and private plans for employers are now being reviewed and submitted between last month and this month. The contributions that are being collected from employees are due to the Paid Leave Authority 30 days after the end of the quarter, and with the dates that are noted there on the slide. We hope to be able to take applications for paid leave benefits starting in December and to then start paying benefits in January of 2022, so less than a year from now. Which employers are covered by the paid leave program or by family and medical leave in general? It will cover employers who have 1 or more people working in the state of Connecticut, including not-for-profits and private sector employers that have unionized workforces. Sole proprietors and self-employed individuals have the option to participate, but if they do, they have to remain in the program for a minimum of 3 years. Those employers that are not covered include the federal government and some employees of the state of Connecticut. Those that are not unionized and not part of a bargaining unit are participants in the program. The same is true for municipalities and local or regional boards of education, unless they too have what are known as covered public employees. Non-public elementary or secondary schools, also known as private or independent schools, are completely exempt from the paid leave program, as they are exempt from family and medical leave generally. As I mentioned earlier, a covered public employee includes these categories: the non-unionized employees of the state of Connecticut, or those unionized employees who collectively bargain to be included in the program. Those that work for municipalities or local or regional boards of education will participate if the unionized employees of either of those employers choose to collectively bargain to be included in the program. If that is the case, then the employees of the municipality or the employees of the local or regional board of education will be included in their entirety, whether they are in the union or not. And you can see at the bottom there's a very broad definition of municipality, which includes towns and cities and boroughs as we usually think of them, but they can also include tourism districts, flood commissions, or an authority that's created by a special act or a regional council of government. When contributions are collected, the 1/2 of 1% of wages, those are remitted by the employer to the paid leave authority. We validate those contributions from information that we receive from the Department of Labor and the Department of Revenue Services. The contributions are deposited into a paid leave trust fund that is managed by the Office of the Treasurer. Those trust fund amounts are used to fund the benefits and to pay for the paid leave program. Now let's have a brief overview of the leave laws. So there are laws that provide job protected leave and laws that provide income replacement. Job protected leave is the ability to get your job back after you come back from a federally or state developed leave. So for federal family and medical leave, which applies to employers of 50 or more employees, workers' compensation, the Americans with Disabilities Act, the Pregnancy Disabilities Act, and the Connecticut Fair Employment Practice Act, each of those laws provides some kind of job protection, meaning the person can take time off from work and the employer has to provide some sort of ability for them to return to their job or an equivalent job. This is also true for the Connecticut Family and Medical Leave Act as it currently exists, but it only applies to 75 or more employees right now. When the law changes in January of 2022, this will apply to employers with 1 or more employees. In addition, the Paid Leave Act will now provide paid leave or income replacement as well as job protection, and workers' compensation will continue to be available for income replacement. Although it should be noted that a person who receives workers' compensation benefits is ineligible to receive benefits from the paid leave program at the same time. Here's just another view of how family and medical leave currently works in the state versus the way it will work next year. As I mentioned earlier, it applies to employers that have employees that total 75 or more. But in order to qualify for family and medical leave now, although it is unpaid, that employee has to work 12 months with an employer and at least 1,000 hours. And then they will enjoy job protection, meaning the ability to get their job or an equivalent job back when they return from family and medical leave. They now get 16 weeks in a 24-month period, but up to 26 weeks is available for military caregivers. And right now, an employer can require an employee to use all of their accrued time, no matter how it is categorized, to pay for the time that they are away on FMLA. The law changes substantially next year in several ways, including the threshold dropping from 75 employees to 1. And that applies whether it is paid leave or not. So I just want to be clear that the family and medical leave law is changing in 2022. There will be no hours worked requirement, and an employee may enjoy job protection after 3 months rather than 12. Then the time off to be taken for eligibility, it will now be 12 weeks in a 12-month period, with an additional 2 weeks that might be available for incapacitation during pregnancy. The 26 weeks of leave for military caregiver leave remains the same. And finally, another significant change is that an employer can require an employee to use their accrued time off as they can now, but they must allow that employee to keep up to 2 weeks of their accrued paid time off, no matter how that is categorized: vacation, sick, whatever that might be. The reasons for leave as identified in the statute are these: to create or expand your family through birth, adoption, or foster care, to care for a family member with a serious health condition, or your own serious health condition, which can include serving as an organ or bone marrow donor or pregnancy. There's special leave available for a family member who's been injured during active duty. And also related to those that serve our country is qualifying exigency leave. So when a family member is called to overseas active duty, a person can take time off to be with that family member to put their affairs in order, arrange for childcare if that's an issue, or to take care of any other issues that might arise before they are deployed. Finally, what is unique to Connecticut's law is that up to 12 days of the 12 weeks of leave can be made available for those who are victims of family violence, which is also known as domestic violence. I've noted a lot of differences between the way that the law exists now and the way that it will look in 2022, but one of the most significant is the change in the definition of family member. Right now, under federal and state family and medical leave, an employee can take time off to care for a parent, a spouse, a child who's under 18, or if the child is over 18, time off can only be taken under family and medical leave if that child has a disability. When the law is different next year, an employee may be able to take time off for caregiver leave for a parent, a spouse, a son or a daughter, really of any age, so that 18-year-old requirement goes away, for their siblings, which is not available now, and grandparents and grandchildren, or people to whom they have an association that is close enough to be considered one of these bonds. In other presentations that I've given, I've often refer to my own personal experience where I had a god sister that I grew up with. She became quite ill, and our family had come together to take care of her. But I was unable to take leave to take care of her under federal or state FMLA because she was not a parent, a spouse, a child under 18 or over 18 who had a disability. If the Family and Medical Leave Act had changed then I would have been able, with appropriate documentation, to demonstrate that I would consider her a sibling and would have been able to take time to care for her as an example. And here is just more detail about what related by affinity means. It does mean any person with whom the person has a significant personal bond, like like family that's listed in the statute, regardless of the biological or legal relationship. And I just gave a personal example of that. Another that's more applicable and for people is when there are people that live together in significant partnerships. They're unmarried, but they may have a familial spouse-like relationship, despite the fact that they are not married to each other. We already reviewed this, but again, the lengths of the leave are 12 weeks and a 12-month period, extended leave of 26 weeks for military caregiver leave, and up to 12 days for family violence leave and 2 weeks for incapacitation due to pregnancy. What are the eligibility requirements for job protected leave? There is no hours worked requirement, and the employee has to work for at least 3 months with the employer to understand job protected leave, to enjoy it and access it. For paid leave, however, there is an income earning requirement, and that is $2,325 in the highest earning quarter of the past 4 or 5 quarters that that employee has worked. And it can be earned from one employer or multiple employers. They also have to have a reason for leave that's covered by the statute, and they have to have not exhausted their leave. They are required to either be currently employed or they had been employed for 12 weeks prior to the time that they apply for the leave. That's immediately preceding the time that they apply, or if they're a sole proprietor or self-employed, they've opted into the program, that they would be eligible to apply for benefits as well. So the role of the employer, I will go through this fairly quickly, but every time an employee may ask you for time off for a reason that might potentially be covered by family and medical leave, we want to be able to ask whether they have job protection under the statutes that I outlined and whether or not they have any income replacement. Excuse me. And both of these questions are important because they may have one without the other. And it's important to avail them, to inform them of both and to have them avail themselves of one or the other or both, because an employee can be eligible, depending on the size of the employer, for federal FMLA only or state or both that run concurrently, excuse me, or neither, but they may have job protection under the Americans with Disabilities Act as an example, or they may not have any job protected leave at all. So a few facts about income replacement. We get quite a few questions about how this might work with any other benefits that employers might offer. In short, and I won't walk through all of these categories, you can coordinate whatever benefits you might offer as an employer with benefits that the employee may receive from the paid leave authority, as long as those benefits do not exceed 100% of the employee's regular wages. I'd like to just point out on this slide a point that's important. A person may qualify for paid leave benefits, but they may not qualify for job protection. And here's how that scenario might play out. Because a person, to qualify for paid leave, has to earn the $2,325 in that highest earning quarter, and it has to have worked for an employer, they may have met those criteria working for another employer. Then they may come to you as an employer on day, let's say they're in month 1 or month 2, before they have any job protection. And they may say, I have a serious health condition, I need to take time off. I qualify for paid leave, but I don't qualify for job protection. They are entitled under the statute to apply for and avail themselves of the paid leave. But you as the employer are well within your rights to say, but you don't have any job protection because you've not been here for 3 months. So we'll hold your job open for you, which you're not required to do, or you can apply for your job and come back, or however you choose to handle that would be an option. But there would be circumstances where a person could access paid leave, but not necessarily have job protection. So just talking a little bit about how a person would access paid leave benefits from the authority, they come directly to the paid leave authority to do that. That is not something that employers need to manage. We then validate their eligibility under the statute and the reason why they are applying for leave. We will do a preliminary calculation. We will ask you as the employer to a couple of questions. We'll ask you questions in 2 categories. First is to validate that the employee actually has covered absences. We don't want employees just disappearing from workplaces by coming directly to the paid leave authority and not informing their employers of their intent to take leave. And then we'd also like to know if they have any vacation or accrued time that you're requiring them to use that might offset benefits that they'd receive from the authority. And then finally, once all of that is done, then we would issue the paid leave benefit. Formula for the paid leave benefit, we often get the question, well, how much will we get? So the paid leave benefit has a 2-part process to it. If the person earns less than or equal to the minimum wage multiplied by 40, which now is $480, they would get 95% of their base weekly earnings. If they earn more than that, then the formula is a bit more complex. They would get the 480 plus a percentage of the difference between the 480 and what they make. But under no circumstances does anyone receive more than 60 times the minimum wage, which would be $720. And as the minimum wage increases year over year, that number will increase as well. A couple of examples of how that might work. So Mike on the left makes less than or equal to the minimum wage multiplied by 40. So he would receive $356.25 in his weekly benefit, which is 95% of his base weekly earnings. Deborah makes a bit more, and you can see here there is actually an application of the paid leave benefit formula. She ends up receiving $612 in weekly paid leave benefit, applying the 480 plus the 60% difference. For those of you who may have spouses that work for the same employer, the law will change a bit. Under federal law, spouses are required to share their leave if they're bonding with a child that is new to their family or they're caring for a parent with a serious health condition. Under state law, they're also required to share their leave right now if, again, they're bonding with a child new to their family or to care for a family member with a serious health condition. When the new leave law comes into effect next year, the spouses will not be required to share their paid leave benefit for any reason. So a bit about private plans. I mentioned earlier that if an employer chose not to participate in the public plan, they still have to offer paid leave, but they can do so by creating their own plan. If they do so, then they are responsible for administering all of the benefits. They don't have to collect the 0.5% and turn it over to the authority. They can still collect it and use it to administer their own private plan, but the withholdings can never be more than what the public plan is withholding from employee pay. If there's an interest in applying for a private plan, that can be done directly on our website, which is ctpaidleave.org, going into the section that's entitled, I want to apply for a private plan. Again, it has to be better or has to be the same or better than the public plan, and generally a short-term disability policy will not suffice. It can't cost employees more than the public plan. It has to cover everyone who works in the state for that particular employer, and those employees who would be subject to the plan have the right to vote on whether or not they want a private plan. There are a number of insurers from whom a private plan insurance policy can be made available, excuse me. And they're all listed here. There are about 15 of them, as you can see, and they're all well-known insurers with a long history in the insurance company space. Finally, we ask that you register your business. And we ask to register so that we know that you're aware of your obligation to withhold the 0.5%, because failing to withhold can mean that you as a business might be responsible for making up those missed contributions for employees, because there's only a certain amount of time that you have to catch up or collect that retroactively. And it can also affect an employee's ability to receive benefits. And we don't want to see employers face any additional monetary penalties for failure to withhold. So we're asking businesses to make sure you register your business on the website and you withhold. The registration process is very easy. If you go to ctpayleave.org, you can't miss it. It's on the very first page you come to. You just hit that button and it will tell you exactly what to do. It is a step-by-step process that takes less than 10 minutes. It even tells you what information you need to gather before you even start. I've covered a lot today. I recognize that. But if you go to our website, as I mentioned before, ctpayleave.org, there are a number of resources that are available to you as an employer and for your employee. We have summarized all of the salient points about paid leave on the employee rights poster and the employee rack card, which are really just a more comprehensive summary and an even more succinct summary of paid leave. It can be found in the employer section of the website. We have a paycheck mailer, if you've not already started withholding, that you can provide to your employees that explains what the withholding is. And everything that I have spoken of today is in this comprehensive employer toolkit that you can find on the site, along with that employee fact sheet. Again, our site is ctpayleave.org, and we ask employers to do 4 things for us, please. Please go to the site and register. If you use a payroll provider, let them know that they're prepared and they should be withholding, because it's going to be time to start sending in those contributions soon. Educate your employees about the withholding by going to the relevant sections of the site, and come back to the paid leave site regularly for updates. We are here to help. We do not have a call center because there are only 12 of us that work at the Paid Leave Authority. But if you reach us through the Contact Us portal on the website, someone will get back to you, and they usually do it within 24 hours. There's also a frequently asked questions section that has, I think we're up to 30 different categories of questions and helpful videos. The entire site is available, and all of the materials are available in English and Spanish. So I'll stop sharing my screen and come back on and say thank you.
Thank you, Andrea. So we do have a question in our QA down here. Anne-Marie, would you like to do the Q&A, or would you like me to cover that portion?
Sure, you can cover it, Amber.
Okay. So our question is, in regards to income replacement and employers requiring the use of PTO, will the trust or private plan reimburse the employer for their share, the 95% calculation of the wages paid during the leave that is also under PTO?
That's an excellent question. And no, there is no reimbursement. So the idea is that the employee let's assume that it's an employee that would have been covered under family medical leave. So you have 75 or more people. This is just for illustrative purposes, not for any other purpose. Most employers require people to use up all of their paid time off anyway. And the reason that they require them to do that is to avoid something called stacking, meaning that a person sort of hoards their time under vacation or sick or any other kind of benefit they would have. They exhaust all of their family and medical leave, either under state or federal, and then they use that other bucket of paid time off for other reasons. So they can end up being out of work for a substantial period of time. That's primarily the reason why employers require employees to use their paid time off at the same time. But there is no reimbursement for that 95%. So what you're saying to them is, let me say it a different way. You're telling them you can go out on leave if you want to. All right, you otherwise qualify because you have a reason for leave and you've been here for, let's say it's been 3 months for their job protection. But they may not have accrued enough time to cover the 6 or 8 weeks or whatever period of time they're going to be out. You would tell them to go to the paid leave authority and get their benefits there so that you wouldn't even be paying them out of their PTO. If they say to you, I'm not going to go to the paid leave authority, I want to use my saved up PTO because I'll get 100% of my benefit there, as opposed to getting 95% from the paid leave authority, they will be able to do that too. But there is no reimbursement mechanism. No.
All right, thank you, Andrea. It would seem that would conclude our questions at the moment. Everyone, I did drop our ConnecticutPaidLeave.org website in the chat. You'll also receive a follow-up email in 2 days with a link to this recorded webinar, as well as a link to the presentation that Andrea has just given in PDF format, which you can download, print, and as you use as you need. So again, if you have any questions, you can submit them in the chat or in the Q&A, and we are happy to help. I'm going to turn it over to you and Anne Marie.
Okay.
If I could
Well,
just say thank you, both of you. I was just going to thank both of you for joining us this afternoon. This is a very helpful information, very important information for business owners to know. I love the new changes in the law coming up in 2022 that sole proprietors will be eligible. I think what's important is that folks understand that they need to be collecting that 0.5% as of January. So we will be making an effort to, as I said, we will put this video on our website so that folks have access to the information. And we may call you again to do another webinar or maybe just a discussion if folks have questions and still have questions later on.
Yeah, we'd be happy to have an open dialogue and discussion. I know we get quite a number of questions about what happens if you haven't been collecting that 1/2%. Yes. Somebody didn't come to your house. I mean, just no. So the answer is no. None of that is going to happen. So I'll answer. I know no one posed that, but I'll actually answer it before we wrap up. So the answer to that is that we at the Paid Leave Authority have already negotiated on behalf of all employers for the state of Connecticut with the Department of Labor the ability to collect up to an additional 1% over the 0.5% as a catch-up. And you can do that through the end of June. So the first 2 quarters of this calendar year. So if you have not started, you need to start right now, and then you can continue. So you can take up essentially up to 1.5% of employee wages. I'm not suggesting this is going to be a popular thing with your employees in particular, but you do have the right to do that under circumstances that we've negotiated with the Department of Labor. If you find that you need more than that to catch up, then that's an individual conversation that you'll need to have as an employer with the Department of Labor. Although we are speaking with them now to see if they would be willing to extend that catch-up period for another quarter, and we'll keep people posted on that. So we don't want anyone to feel as if all is lost and they just have to turn in whatever they have and hope that we don't find them, because we've heard people tell us that too. That's not a good strategy. So go ahead and withhold and use that catch-up period, and we'll try to do the best that we can to work with you.
Excellent. Again, I'd like to say thank you on behalf of the Black Business Alliance and the Southern Connecticut Black Chamber of Commerce. Again, we appreciate your efforts, and we will continue to stay in touch and learn more as we go along with this process. Thank you.
Okay. Thank you very much. Thank you.
All right. Have a good afternoon, everyone.
You too.